David Katz, welcome. Thank you
Great
for being
to be
here.
with you.
Yeah.
We had a little bit of technical difficulty, but John really saved the day. So thank you, John.
Oh, wow. John,
You'll get your $5 in the mail.
Daily.
Yeah. John he's wearing a lot of hats. We all are wearing hats, but I think John wears them better than many in this mix because he's
this one is a fedora.
Yes, able to do many things. I was just speaking about Lindsey Graham's legal exposure involving this Georgia case. And the reason I mention it, I really want to get your take, David Katz, because Lindsey Graham really did try to get votes thrown out.
Well, Lindsey Graham is very eager not to testify because I think that he would either have to plead his rights under the Fifth Amendment, which is not a good look when you're a sitting U.S. senator, or he would have to say things that would be very incriminating of himself and of the whole Trump team. And so he's trying to hide behind this speech and debate clause, which I don't think applies to him at all. As it is, they're willing to limit his testimony, but actions that he took, cajoling officials in Georgia, are not speech and debate in the Senate. It's one thing to not be questioned in another place if you've made a fiery speech or you've insulted somebody on the floor of the Senate. You can't be sued for libel. You can't be, quote, questioned in another place. But it's not carte blanche to commit crimes. You know, the president's not above the law. No one's above the law. And the 100 U.S. senators are not above the law. His position is ultimately ridiculous. And I think the Supreme Court will eventually require him to testify. But, you know, these guys are all about the delay. And so, you know, they get past the midterms, they get past the next thing. Maybe the Georgia case just proceeds with other witnesses. They try to put it behind them, but not because he has a really valid legal position. And one last thing, Justice Clarence Thomas, of course, should have recused himself. Even it's fairly administrative stay at this point, but even to grant this administrative stay, even to grant 1 week of stay is not something he should have done. He should have recused, let another one of the 8 justices do it. But of course, he doesn't intend to recuse himself from the case at all, does he? He plans to rule on all the January 6th things, even though his wife was a participant.
And when you talk about recusal at the Supreme Court level, it's you're saying he should recuse because of the last point you made, which is that his wife is connected to all of this. Isn't that essentially it?
Well, yes, that's it. And there is a law which says that he's not supposed to rule on anything in which a spouse has an interest. And you can kick around, does that mean a financial interest? Does it mean a legal interest? Does it somehow exclude a political interest? But it seems to me that the statute says interest. Of course, a prudent Supreme Court justice would err on the side of caution. Of course, with Thomas, we don't have a justice who errs on the side of caution. He seems to be all in to help Trump and his wife as much as he can. I mean, that's the only thing that I can take away from it. You can argue about some of the things that Kavanaugh does. I often agree with things that Chief Justice Roberts does. But when it comes to Clarence Thomas and this particular issue, he just seems to be all in and says, you know, basically, Mark, stop me if you can. And it's very hard to stop a willful U.S. Supreme Court justice. Yeah, and I'll remind everybody, David, that, and you'll correct me if I'm wrong, but he was the justice who tried to withhold when it was appealed to the Supreme Court, the text messages that went down. The committee was trying to get text messages that pertain to the January 6th attack. And you were, am I right? You can tell me if I'm wrong here on this. He was all the justices voted that, you know, that the congressional committee is entitled to that information. I think it was or the Justice Department, I forget which. And but one Supreme Court justice said, no, I don't want those communications to actually be released. As it turns out, his wife was very much a part of those communications. And so Clarence Thomas, in that case, didn't recuse either. Well, the decision was 8-1. And of course, history will take note. I mean, it's questionable what we can do right now about it, but history will take note that this was one of the most corrupt actions by a Supreme Court justice ever, because as you said, when they were over his one dissenting vote released, there was his wife's name in communications with Mark Meadows about January 6th. And it was obvious that he should have recused himself from that case. And of course, the question is, you know, what to do. And it actually is a problem to try to put any review over the U.S. Supreme Court. It's the highest, you know, point of one of our 3 branches of government. It's the check and balance. Who can really check them? Now, a Congress that wanted to could cut their budget. It could do other things like that. I mean, if the Supreme Court got into a real battle with Congress and Congress had made up its mind to set down, principles and rules for the Supreme Court, the truth is that Congress has an awful lot of power, but they're not really consistently into many of these issues, Mark. And so basically the Supreme Court sometimes acts more powerful than the other branches. They say it was the least dangerous branch. And you look at something like Dobbs, it's pretty dangerous branch sometimes, isn't it? The third branch.
It seems as though it's the branch that is most effective in getting things done right now. I mean, I'd suggest that what they're getting done is ain't good, but they aren't encumbered by having to get a 2/3 majority or this kind of thing. I mentioned 2/3 majority, and it's good in the context of the Supreme Court to remind people that, because I hear a lot of this, well, can't they impeach Clarence Thomas? Can't they? The impeachment of a Supreme Court justice, you'll need a 2/3 majority, and you'll need a 2/3 majority to expand the court. So that whole thing about the Democrats are going to expand the court, they can't expand the court. They can't get an infrastructure deal with everything that was on the wish list passed. They had to make significant compromises. So not saying it wasn't a significant piece of legislation, but I'm just saying a 2/3 majority to either expand the court or remove Clarence Thomas, forget it.
Well, Mark, actually, that's one that it's good you have a guest with my long legal experience, and in particular my interest in this topic. I was going to write a book about this 3 or 4 years ago when the Kavanaugh confirmation was such a hot topic about whether you could expand the court, because you could see it coming 5-4, and now with Barrett you can see it coming 6-3. It is 6-3. But the reality is you can expand the court by mere legislation, Mark, because the Constitution doesn't call out a specific number of justices on the Supreme Court. And Lincoln expanded the Supreme Court to 10. It was 10 for a while, 10 justices on the Supreme Court. Then I think one of them passed away or retired, and so they went back to 9. And then, of course, there's the famous incident where FDR tried to, quote, pack the court. It was a very complicated plan. It would have expanded the court, and it could have been done by a majority of both houses and the signature of the president. So actually,
So is it just a simple? Sorry, David, but I have to get this clear, because I was under the impression that it was a 2/3 majority. But you're saying it's a simple majority from House and Senate?
Yes, it's a simple majority. Now, as you pointed out, it would be subject to probably the filibuster rule because it's a major piece of legislation. But the filibuster is only a creation of the Senate. The Senate could sit right now and say, you know what, on certain issues, we're carving that out. And but they could carve this one out. But it's a matter of the Constitution. As a matter of law, they could do it with a simple majority in the House, in the Senate. The president signs it, and they could have 11 members of the Supreme Court or 13. Now, people say, well, then when the Republicans get back in power, they'll go to 15. And my point always is, and Pat Thurston and I used to kick this around all the time, is that, okay, if you're so afraid of what's going to happen in the future, you're not going to get anything done in the present sometimes. And you know what? Let them go to 15 if that's going to be our fate in 10 years. But for now, what are we going to do about the environment? What are we going to do about Dobbs type of cases on the Supreme Court? What are we going to do about some of these rules that a state legislature can do whatever it wants and not even be reviewed by state courts? Forget the federal courts. The Supreme Court might rule that even the state courts can't rein in a state legislature. I mean, look, people are going to just live with those decisions because this court's 6-3. They're going to just live with them for decades and decades. And
couldn't agree more.
Which does not require.
Say it again. It does not require what, David? Say it again. The last part. It does not require.
It does not require anything more than a simple majority in both houses. It would require a majority of the House, which may go Republican. It would require 50, or now with Vice President Harris, only 50 votes in the Senate, and could be done. They'd have to carve out this piece of legislation from the filibuster rule, and the signature of Biden. You could have 11 or 15 or 13 members of the U.S. Supreme Court. My own recommendation is 11. I think 11 is elegant because it puts Roberts right back in the pivotal situation. And you could say, you know what, we're not really changing the dynamic that much. It's just the way the world was when Kennedy was the swing vote, or with Roberts as a swing vote. 13, of course, would give the Democrats a majority. They'd go from 6-3 to 7-6 with 13.
Well, it's I'd love to hear it talked about at higher levels. It seems to be a third rail. It's always used as a a talking point by the GOP, but I don't really hear any serious conversation about it at the highest levels of the Democratic Party. But that for the next time. David, slowly we get all the technical stuff worked out, and it'll be easier and easier every time. So I appreciate you being here. David Katz, you can see the former assistant U.S. attorney on Twitter at David Katz Law. You can reach him there if you have any further comments on this conversation. But let's do it again next week. All right, David, thank you.
Great to be with you, and we'll get it better organized next week as we keep rolling.
Yeah, you got it. No problem. Thank you, pal. All right. David Katz, everybody.